Convicted felon Donald Trump had his first probation officer meeting this week. We learned that he had 3 firearms, 2 that were already turned in to Manhattan after he was indicted in the criminal case in Manhattan. He still has 1 gun apparently still in his possession. A felon with a firearm. What are the implications? We will discuss as we move closer to that July 11th sentencing date. Then we're going to talk about Supreme Court rulings this week. There were no rulings, however, on the issue of Trump's claim that he can order SEAL Team 6 to kill his political opponents, claiming that he has absolute presidential immunity in perpetuity. And there's no ruling for the obstruction of official proceeding case, and that involves 2 of the counts against Donald Trump. But the Supreme Court did make rulings in the cases of Garland v. Cargill regarding bump stocks and FDA versus Alliance for Hippocratic Medicine regarding women's reproductive rights. We'll break down the rulings there and the implications. Also, Judge Eileen Cannon continues to make up her own rules as she goes along, or should I say, whatever Donald Trump wants her to rule. Can special counsel Jack Smith appeal? We will break this down and more on Legal AF. Michael Popok, just because there are not a lot of developments in the Donald Trump related cases doesn't mean that there are not a lot of developments in other cases as well. We're at that point where the Supreme Court concludes its term by issuing all of its decisions, and in kind of typical fashion for the Roberts Court, which kind of in every way has caused major question marks, I think would be putting it lightly, regarding the approach that they have to basic law, basic precedent, and just kind of basic decency. They wait till the very end to kind of dump the most important rulings. And even to this date, they have not ruled on absolute presidential immunity, and kind of thereby really stopping important cases from moving forward. Michael Popok, how are you doing today, sir?
Fantastic. Ready to jump in with both hands and both feet and talk about SCOTUS, what's already happened and what we expect will happen.
Well, look, we're headed towards the July 11th sentencing date. Lots of people debating whether or not Donald Trump is going to be thrown into prison based on being a convicted felon. You and I have discussed that matter at length. We've also discussed it with Karen Freeman-Agnifilo, the former number 2 at the Manhattan District Attorney's Office. It should be noted that if you were probably to go back 2 years ago or so, maybe more, when you and I really ramped up Legal AF, and it's existed for longer than that. But as things were really ramping up, and you and I were saying that, look, we think there are going to be criminal charges brought against Donald Trump. We think that there are going to be these civil cases brought. I think the prevailing narrative out there is that's never going to happen ever. I remember very distinctly when we had Alvin Bragg on a interview with Karen Freeman-Agnifilo. There were a lot of criticisms directed his way, would be putting it lightly, from people who were watching and saying, no, you're weak, you're not doing the right thing. And, all we were saying is, I don't think that you are following all of the data, because the data points aligned with pretty much where we are today. And where we are today is that Donald Trump is a convicted felon on 34 separate felony counts, number 1. Number 2, in the various civil cases, he has over $500 million in judgments against him. What's a bit hard to predict if you are law and order people like you and me, although it is, kind of clear to see the direction of where this Republican Party has gone. I mean, I think it would have been hard to predict just how obsequious that they were going to be, that they would actually have MAGA Republican members of Congress who were supposed to be a co-equal branch get quite literally dressed up by Donald Trump in outfits that he wanted them to wear with Donald Trump ties, with Trump's face on their ties, and that they would invite Donald Trump back after becoming a convicted felon to Washington, D.C. And as he rants about Hannibal Lecter and says how much he hates the city of Milwaukee, and how he makes these just odd and false statements about potentially being in romantic relationships with Nancy Pelosi, and says that that's what Nancy Pelosi's wacko daughter told him. And, just the disparaging remarks about Nancy Pelosi's daughter lying about romantic relationships with her. And then then the MAGA Republicans, give him standing ovations as he's saying things like that. I think that's a little bit harder to, I wouldn't say harder to predict. I think it's a little bit harder to stomach that that exists. But, here we are right now. And now Trump's meeting with his probation officer. I want you to tell us about that meeting. And we're heading towards sentencing. And if Justice Merchan, who's a law and order judge, follows the law, there will be prison time. Does that mean Trump will be serving time in Rikers or home confinement? That's a little bit where I think there's some ambiguity and there's a significant debate. But I think that Justice Merchan, when he applies the factors, is the person showing remorse, prior conduct, severity of the crimes, behavior during the trial, behavior before the trial. I think you put that data into all the inputs. You're a law and order judge. You have to order some form of incarceration or home confinement for not an insignificant period of time. But walk us through the probation officer meeting, this idea that Donald Trump had firearms. He still has one firearm. Does he have to surrender that? You practice in New York, so you are a little bit closer to it than I am, and you've been speaking to a lot of New York criminal lawyers about this case as well. Break it down for us, Michael Popok.
Okay, Ben. So the process is we got a 34-count felon. Will be adjudged a felon on July the 11th during that sentencing hearing. In the meantime, the judge takes in input from Donald Trump. Defense will write a sentencing memo, arguing, I'm sure, for nothing, arguing again because it'll be a campaign screed masquerading as a sentencing memo. So I'm sure when we see it, and I think it's coming up this week, the week coming up, that it will be an argument for why there's reversible error and the judge overstepped his boundaries and he let evidence in that he shouldn't have, and he'll be reversed on appeal. And or if there is any sentence, it should be suspended until an appeal happens, or it should happen till after the election. Otherwise, it's election interference. It'll all kind of get wrapped up there. Prosecutors are going to have to do the same thing. Prosecutors are going to have to make their sentencing memo, which comes in later June, towards the end of June, about 2 weeks before the sentencing hearing. And they'll put in, their survey of, there's no real comparable, there's no real exemplar for what a former president interfering with the election in order to get reelected. There's no comparison for that. But they will talk about the thousands and thousands of other people or companies that have been convicted of similar crimes. Yes, first-time offenders, but what they've received, and they'll argue for some sort of, I'm sure, incarceration. What the shape of that is, the contours of that are unclear. Is it home confinement? Is it on an army base? Where is it? Because any incarceration means that the judge is sending the Secret Service to jail as well. Because by law, for now and for the foreseeable future, Donald Trump is entitled to Secret Service protection. And so that's got to weigh on the mind of Judge Merchan as well. Then the third piece of the puzzle of an input into Judge Merchan's ultimate decision, because he makes the decision with broad discretion to do so as a trial judge in New York, comes from the probation department, which is an independent agency that's responsible for putting together a package of material and a pre-sentencing memo and recommendations to the judge. Part of it is an interview with a convicted defendant. That usually takes place in person. Since COVID, they've been allowing some people to do it by video. The judge cut Donald Trump a little bit of a break and allowed Todd Blanche, his lead defense lawyer, to be in the room for the Zoom interview that lasted apparently about 30 minutes. I assume it lasted so short because most of what you need to know about Donald Trump for sentencing purposes is already in the public record. Just because the probation person spent 30 minutes doing the live interview, I don't think reflects the amount of a dossier that they are preparing about one Donald J. Trump, his past record, his past civil fraud record, findings against him by judges that he committed fraud or perjury when he testified or lied under oath, civil judgments against him. All of these things are public. And so putting together a litigation report, a how many times has this guy been convicted or prosecuted report is in the public record. We know it, we do it, but probation can do it too. So that's not what they were trying to get out from him. They weren't going to waste anybody's time asking him about, like, acting like they didn't know who he was. Like, have you ever had a civil fraud judgment against you? Yes. So they had all that. So they wanted to get down because it is a part of a due process to have the defendant who's now been convicted speak. And if he shows contrition, to note that in the sentencing, we're confident that Donald Trump did not show contrition. To show acceptance of responsibility, that would be noted. We're sure he did not accept responsibility. There's a psychological background thing that may or may not have happened already that should be happening before it goes to the judge. And then when they're done with that, and in this interview is where you and I reported about the revelations about the guns. We were all floored here on Legal AF when we learned in March that Donald Trump had weapons and had an active concealed weapons permit in the state of New York, which, by the way, is very hard to get until the Supreme Court made a recent ruling 2 years ago. It was almost impossible to get a concealed weapons permit. Somehow he got it and had apparently 3 firearms. Okay, he turned in 2 of the 3 firearms, either didn't disclose the existence of the third or failed to turn it in. Because as a condition of his release, this is all before conviction. A felon holding firearms is a different issue. We'll get to that in a minute. Pre-conviction, while you're just a garden variety defendant in a criminal process, as a condition of your release in 4 different criminal cases around the country, every one of them said you can't have a firearm. And it's for a good reason. We don't want law enforcement, if they have to go serve you with a subpoena or a search warrant or go pick you up because you violated the terms of your release, they don't want to have, the person have weapons. It's a good reason. So he turned in 2 out of the 3, but he disclosed that at Mar-a-Lago, he had a third weapon that he never turned in, which is a violation of his terms of his release everywhere. And I'm sure the prosecutors are scrambling to go look into it. The Palm Beach, Florida, the town of Palm Beach Police Department, having been alerted about it, say they're investigating, because you're not allowed to have, a felon is, now we're into the world of felons, terms of release or otherwise. If you're not allowed to have a gun, the local police want to know about that, as may in the case of Mar-a-Lago and DC, the Department of Justice and the FBI. So that was it only took Donald Trump, 20 minutes into a 30-minute interview to reveal that he probably violated terms of his conditions of his release and probably crimes. Now that he is a convicted felon, or will be on July 11th when the judgment of conviction is entered against him formally along with the sentence, he can't have guns. And so if he has them and he hasn't turned them in, then that's another crime. We just saw a person related to the president who for 11 days had a handgun that he probably shouldn't have had, a revolver, and just got convicted. So it is serious business, and it's risky for him not to have done that. Now with that information and the filings that you and I will be able to report on, the first one, I think Trump's first, his sentencing recommendations, then the last word is the prosecutors, and then it goes right to that hearing. It won't be a live hearing or audio recorded or video recorded, but we'll be able to get people into the room and understand what happens there. And then, as you're right, Ben, the judge has a difficult thing to balance here. On one hand, you've got somebody who, in all of the bad conduct that was not allowed to go to the jury to try to convict Donald Trump, is fair game in sentencing. So all of the the acting out in court, outside of court, bashing the process, bashing the judge, all of that can sort of go into the judge's stew of what he's going to mete out as a punishment. So if Donald Trump thought, oh, I get away with it, all these bicycle rack interviews that he gave, all these hot mic moments all around, they'll all be factored in. And if the prosecutors don't pull it all together in their filing, then then you can be assured that the clerks for the court will also put that together. And the fact that he hasn't showed remorse, Trump, he hasn't accepted responsibility, and he made the prosecutors spend 2.5 years and hard-earned taxpayer dollars investigating, prosecuting him, going through a 6-week trial, putting on 23 or so witnesses. You don't get credit for that. And you normally, as Karen said in a recent interview that she gave with Huffington Post, usually that means the whole prison sentence thing is amped up and the judge throws the book at you. If you had cut a deal earlier, which we knew he would never in our wildest dreams ever do, but if he and his lawyers went to the prosecutors earlier and said, you know what, this is a misdemeanor at best, we'll take a misdemeanor, recommend probation or whatever, slap on the wrist, and we'll take it. I'm not saying the prosecutors would have taken it, but Trump certainly wasn't going to go do that. And so he made the people go through an entire trial, and there should be repercussions for that at the time of sentencing. I think, I'll leave it with this, Ben, I think that the way the judge sort of threads the needle here is that he's going to put together a package of sentence components. One part of it's going to be, I believe, some sort of incarceration. I don't know if that's home confinement or that's real jail or something like that, but there's going to be. I don't know if that's 2 months, 3 months, 4 months. I don't think a year, somewhere in there. And then all these other things, probation and community service and some sort of fine. And then I think he's going to, taking a page out of what Judge Nichols did in the Bannon case, which although federal, sort of is a recent exemplar, is that he'll allow him to be out pending an appeal. He'll give him a deadline to file his appeal. And pending that appeal, which could take a year to 18 months in the New York court system, starting with the first department, the intermediary court that sits in Manhattan, and then going up to the Court of Appeals in New York, he'll let him stay out because first-time offender, nonviolent crime, until that appeal runs. And just like we saw with Bannon, after 18 months, the judge said, okay, enough is enough. You now have to report in July for it to go to prison. And so I think that's how he'll do it, to allow him to still be campaigner Trump, see what happens in November. Not that that would affect the sentencing. Sentencing would already be given out. But in terms of when he would have to report, I don't think he's going to say, okay, sheriff, take off your belt and your shoes. You're going now, with the sheriffs here, with the bailiffs here, and you're going to be taken away. I want to manage expectations. I do not believe that is going to happen on July the 11th.
I spoke recently with a former federal prosecutor who said, one of the implications of Trump's behavior that's not getting enough attention is the message it is sending to other criminals about our criminal justice system, that you can somehow not take our criminal justice system seriously, that it is totally for sale, that you can behave like Donald Trump and not have consequences. And that is the exact opposite precedent that needs to be set, especially by people who purport to be leaders. And when the Republican Party invites Donald Trump to the Capitol Hill Club after already being found to be an adjudicated rapist, after Donald Trump's already found to have been found liable for massive civil fraud, liable for defamation, liable over and over again, and now a convicted felon, it sends a message to the country, and it's not a good one, and it's not why you and I went to law school, and it's not what our values of law and order should be. One other point I'll just mention too is, as of this show, Justice Merchan has not ruled yet on Donald Trump's request to be let out of the gag order. Recall that Donald Trump previously made that request in a letter motion. The district attorney's office opposed that. And what we can say right now is Justice Merchan is certainly not taking any sort of urgent or emergency action in response to Donald Trump's request that was presented now about 2 weeks ago or so. So we will keep monitoring that. I've predicted that eventually when Donald Trump tries to back out of the debate, one of the excuses that he's going to make is that the gag order is in effect and he won't be able to do the debate, among other things. He'll claim that President Biden's on drugs. He'll claim that it's all rigged, and he'll make a number of other excuses. But I wanted to put that on everybody's radar as well. I also want to put on everybody's radar as well some major Supreme Court decisions. You and I are going to cover just two of the ones that were issued this week. But then on our Patreon, one of the things I've prepared, which I'm going to post, I'll make sure I have it posted by the end of this weekend, is a lecture on all of the major Supreme Court cases this term. It's going to be very geeky. It's going to go into a lot of detail. It's going to be exactly how I would teach it at a law school level. So if that's not for you, don't worry. But if you want to take a deeper dive and hear that lecture, take notes, and I think you'll enjoy it. It's patreon.com/legalaf, patreon.com/legalaf. Michael Popak and I will continue to post lectures there, and I'm excited to do the lecture on the Supreme Court, other cases that we can't cover on this episode based on the timing. We'll be right back after our first quick break, and we'll discuss Garland v. Cargill and FDA versus Alliance for Hippocratic Medicine. Then we'll talk some more about the Mar-a-Lago document case and the status thereof. Let's take our first break.
Most clothes are uncomfortable or too tight, or never actually the size you really are, not to mention the annoyance of trying to put a good outfit together. Everyone wants to dress their best and look good at all times because, frankly, it's a confidence booster. I regularly wear Rhone when I do the podcast or on Hot Takes. So here's the deal. Men's closets were due for a radical reinvention, and Rhone stepped up to the challenge. Rhone's commuter collection is the most comfortable, breathable, and flexible set of products known to man. And here's why. Rhone helps you get ready for any occasion with the commuter collection, which offers the world's most comfortable pants, dress shirts, 1/4 zips, and polos. Rhone's comfortable 4-way stretch fabric provides breathability and flexibility that leaves you free to enjoy what life throws your way. From your commute to work to your 18 holes of golf. It's time to feel confident without the hassle. With Rhone's wrinkle release technology, wrinkles disappear as you stretch and wear the products. It's that easy. With Gold Fusion anti-odor technology, you'll be smelling fresh and clean all day long. And on top of that, Rhone is 100% machine washable, so you can ditch the dry cleaner altogether. Rhone has truly become my favorite clothes. We're on the move a lot. Whether it's jumping from meeting to meeting or catching a flight or a dinner out, the Rhone commuter collection has never let me down. Even after I wear it all day, I still feel super fresh because of that Gold Fusion anti-odor technology. Head to Rhone.com/legalaf and use promo code legalaf to save 20% off your entire order. That's 20% off your entire order when you head to RHONE.com/legalaf and use code legalaf. It's time to find your corner office. My days have been jam-packed for as long as I can remember, which makes winding down at night a tall task. Luckily, it's great sleep summer with our partner, Via Hemp. No more counting sheep just to be awake at 3 a.m. And trust me, I've been there. Via Hemp is a company dedicated to harnessing the natural benefits of hemp to create high-quality wellness products. Trusted by over 250,000 customers, Via Hemp aims to empower individuals to enhance their quality of life naturally, offering solutions that promote sleep and relaxation with their new Dreams formulations, which now have passion flower and L-theanine. Via offers 2, 5, and 10 milligram options for them, as well as their 0 milligram Zen, allowing you to customize your sleep journey. Via is the only lifestyle hemp brand offering a craft cannabis experience. They use compounds found in hemp along with active plant extracts to create products, each with a specific effect in mind. Whether you want to get better sleep, ease anxiety, or enhance your mood, they have something for you. And the best part, Via legally ships to all 50 states in discreet packaging directly to your door with a worry-free guarantee. No medical card required. So if you're 21 and over, check out our link to Via's website and our description for 15% off. Keeping up with the hectic political and law news cycle, along with being a practicing attorney, keeps my brain constantly racing, which is why I've been in love with their dream formula for gummies. It always drifts me right to sleep, and the best part is I wake up feeling completely replenished. If you're 21 or over, check out the link to Via in our description and use the code LegalAF to receive 15% off. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Get the rest you deserve with dreams from Via.
As I said, those are not just ad reads. Those are experiences. And Michael Popak has glasses for each and every ad read, for each and every moment. And so that's one of the things I appreciate about
Via.
I thought
orange tinted glasses for Via.
And you nailed it. If you want to support our pro-democracy sponsors, the discount codes are in the descriptions below. Let's talk about the United States Supreme Court decisions from this week. Let's talk first about Garland v. Cargill, then let's talk about FDA versus Alliance for Hippocratic Medicine. Garland v. Cargill, the question in the case was whether a bump stock, which is an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger to fire very quickly, 800 to sometimes 1,000 rounds per minute, converts the rifle into a machine gun. The United States Supreme Court holds that it is not, and therefore it can't be banned under a 1986 statute which banned civilian use of machine guns. Just to give you a further definition of bump stocks, just so you know, bump stocks are a piece of molded plastic or metal that replaces the butt of a rifle and the handle closest to the trigger. The piece allows a portion of the gun to slide freely back and forth. The recoil from a shot causes the gun to bump between the shooter's shoulder and trigger finger, causing shots to be fired in quick succession. Americans bought about 520,000 bump stocks between 2008 and 2017 while they were legal in response to the Las Vegas shooting where 60 individuals lost their lives and hundreds were injured. I know, Michael Popak, you were not specifically in that concert, but you were close by in Las Vegas that day as well. But in response to that tragedy, the ATF banned bump stocks for civilian use by looking at their enabling regulations about what they're supposed to do as the ATF. They looked at the 1986 statute that defines machine guns. They determined that they had the ability to regulate this specific bump stock, this device. And so they said, no, it's banned. And the fact that it wasn't banned before is not an admission that it was legal. It's just, as an agency, it was a new device that was around. The ATF had always said it was looking into it. And when this tragedy struck, like that happens, as tragedies happen across the country, that tragedy is an avoidable one, definitely an avoidable one that happens too frequently here. But then agencies which are equipped with this authority, with this types of authority, take action. That's the way that's why we have agencies, right? But the Supreme Court, which has been taken hostage by this federalist wing, in addition to their views on the Second Amendment, which they've basically held that the Second Amendment provides almost unfettered ability for Americans to have weapons of war. This case was decided on kind of another doctrine, not even necessarily the Second Amendment, but this other federalist doctrine to try to basically take down the federal government that says, unless Congress specifically uses magic words, in this case specifically mentions bump stocks by name, an agency can't do anything. They can't take any action. And I'm sure if you go back to some of the other legal AFs that we've done, you've seen that this is a way the Supreme Court has struck down common sense regulations from agencies, whether they were related to COVID, whether they were related to the environment, whether they were related to kind of other common sense actions that could be taken by agencies across the spectrum, saying Congress has to specifically say magic words. If Congress acts in a broad fashion and gives you kind of broad powers, that's not sufficient. It has to say the magic words. And look, we all know that Congress never does that. That's not something I wish Congress could actually act and do that. But right now you have a Congress led in the House of Representatives by MAGA Mike Johnson and MAGA Republicans who are utilizing Russian and Chinese spies to launder in false information, and then they're turning it over to Rupert Murdoch properties so they could run headlines Joe bribing based on fake audio recordings that don't exist that come from Russian spies. I mean, that's the status of Congress. So is Congress going to and they're bought and paid for by the NRA and other special interests. Are they going to use specific language? So it's also kind of a gaslighting by the Supreme Court so they can strike down really important things that help the American people. But then the Supreme Court can also then say, but look, what we're saying is we're not against the idea of banning bump stocks. It's just Congress needs to act. That's all we're doing. It's a gaslighting thing the Supreme Court does. Because look, take a look at the definition of machine gun in the 1986 statute. It says, the term machine gun means any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without manual reloading by a single function of the trigger. The term shall also include the frame or receiver of any such weapon, any part designed and intended solely and exclusively, or combination of parts designed and intended for use in converting a weapon into a machine gun. And that's what the bump stock does. It's intended to convert a semi-automatic weapon into a machine gun-like device. And that's what was made very clear in the dissent by Justice Sotomayor, who first and foremost said, you all claim to be strict textualists. How much more textually strict can you be than what Congress said in 1986 about the parts? And then Justice Sotomayor said, today the court puts bump stocks back in civilian hands. To do so, it casts aside Congress's definition of machine gun and seizes upon one that is inconsistent with the ordinary meaning of the statutory text and unsupported by context or purpose. When I see a bird that walks like a duck, swims like a duck, and quacks like a duck, I call that bird a duck. A bump stock equipped semi-automatic rifle fires automatically more than one shot without manual reloading by a single function of the trigger. And she cites the statute, section 5845B. Because I, like Congress, call that a machine gun, I respectfully dissent. And finally, before passing it over to you, it's worth noting that Justice Clarence Thomas wrote the opinion of the court, that it was a 6-3 decision. It was a right-wing Supreme Court-led decision. The 3 justices in the dissent were the Democratic-appointed justices. The 6 justices who are now putting bump stocks in civilian hands are the Republican-appointed justices, including 3 appointed by Donald Trump. And with all of the news that's come out recently about Clarence Thomas's corruption, which we knew about before, but every day it seems there's another $1 million he's received and been bribed by billionaires to do their bidding. I think we're up to $4 to $5 million now with all of these trips that he's taken. Justice John Roberts, the Chief Justice, assigns who writes these decisions. So the fact that Justice John Roberts, even in all of this, not only is part of that majority, but giving the decision to Justice Clarence Thomas to write is also, I think, a screw you to the American people as well, and intentionally done. Popak, I know I ate up a lot of that apple in that one, so I'm going to let you talk about the other case as well, FDA versus Alliance for Hippocratic Medicine, and I'll let you take more of that one. But I know you want to comment on Garland v. Cargill as well.
I'll do it from a broader perspective. The problem with this Supreme Court is that they've spent last two terms with an agenda. And the agenda is to roll back administrative agencies through their interpretation of the Administrative Procedures Act. And if they don't see literal text to support the delegation of authority by Congress to the agency that's responsible for regulating in that particular area, EPA, environmental protection for clean water, education for the education department, ATF, alcohol, tobacco, and firearms for guns. If they don't see it literally there, they've taken a position through judicial activism that the agency has gone too far. We all recognize or we should recognize that government would be immobilized if they could only rely on what Congress writes, sometimes in slapdash format, throwing it together, sometimes the last minute, 5-page, 10-page, 100-page statutes. Sometimes they're artfully drafted, usually in consultation with lobbyists or written by lobbyists. Sometimes they're not. But Congress always delegates and expects that the real rulemaking is going to be done through the Administrative Procedures Act and by the agency that has substantive knowledge in the area, that takes in information from the industry and from consumers, that holds hearings, and that through rulemaking creates rules to implement what the law and policy that's been established by Congress. That's why we have a code of federal regulation, the CFR. The CFR is this giant set of rules that when Congress talks about aspirationally, and maybe with some meat on it, about clean water or clean air, or what they're going to do about drilling or fracking or gun control, they leave it to the experts, substantive experts in these agencies to actually backfill with the regulations. It's always been, and it always will be. We couldn't operate a government properly just relying on what Congress was generating in terms of the law, if you will. And that's why there's this is allowed to be this delegation. They are unique among the three branches. The president, occupying the second branch, operates through will, force, and powers given to him by the Constitution and executive orders. The Supreme Court is 9 people and operates through issuing orders and decisions like the ones that we're talking about on legal AF, and regulates things below them at the federal court system and through budget being allocated to them, and sets those rules and procedures for litigants and for the public, and then sets precedent and laws. Congress, Article 1, right? It has the power to do all those things, to set the law of the land, the federal law of the land, and to regulate in areas where they choose to regulate, and to oust state regulation where they find it appropriate. That's our system of federalism. In order for them to do that, however, that task of regulating all conduct and behavior effectively in industries in this country, okay, from securities to environment to education to loans to consumer protection, so on and so on and so on. They have to rely. They don't have enough hands to pull all the levers. They've got to have these agencies. This Supreme Court thinks that the agencies have run amok primarily under Democratic control. And so they've spent what seems like a lifetime, but at least the last 2 terms, including this one, trying to roll back administrative and even executive acts. Because, with all due respect, Trump actually was one of the ones that signed an executive order related to the bump stock banning as well. Even he thought it had gone too far after 60 people died in Vegas the night that I was there. I'll talk about my personal experience in a minute. So that is counter to decades of proper discretion given by courts to the agencies charged with their responsibilities because they're subject matter experts. That deference is over with this court. And you see it most acutely and most in a most depraved way when it comes to gun control. Clarence Thomas is the same person who 2 years ago wrote the New York rifle and pistol decision, which completely changed the relationship between guns and people in this country, and wrote out, much to our chagrin, I know yours particularly, Ben, the well-regulated militia language of the Second Amendment, and basically said people have the right to carry handguns and it can't be regulated or limited unless you find a historical analogy back in the 1800s that was similar, without reference to the fact that the 1800s had a lot of things contextually that, of course, the court ignores that we don't want to repeat. Women as second-class citizens, Black Americans, not even Black Americans, second-class citizen slaves during long periods of that. And yet we're going to go back to old-timey times to find historical precedent to decide whether a particular gun regulation should survive or not. It's so bad now that even Amy Coney Barrett, in another opinion that came out this week involving, of all things, copyright, took on the consistent use of historical precedents instead of judge-made tests to set law. She said it's gone too far. What happens if you reach a regulation where there is no historical reference? What if you're doing nuclear power regulation? Well, you can't go back to old-timey times for that. So you're just delaying the inevitable. Eventually, you'll run out of regulations in the modern world on artificial intelligence. You can't go back and find an 1800 analog for that. And so even she's getting annoyed, yet she sides consistently, of course, with the majority. Here, you've got what looked to be, to every rational human being, except for this United States Supreme Court MAGA majority, to be the easiest way to take weapons of mass destruction out of mass shooters' hands. The bump stock, and I'll just dive into this for a minute. Total coincidence, total negative serendipity. I'm in Vegas the night of the Harvest Festival shooting. I'm there because I'm going to court on that Monday, and I came in a day early. And I'm waiting for colleagues of mine to arrive to have dinner. And while we're at dinner, we get a text from one of our colleagues who's about to land at the airport. The airport in Vegas sits alongside or nearby the open field where the Harvest Festival was held, many hundreds of yards away from Mandalay Bay, the hotel. And we get a text that there are people running onto the tarmac. And we were like, what do you mean people are running onto the runway? What do you mean? And then within minutes, we get security coming into our dining room because we're having dinner, telling us everybody's got to get up and move right now. And I had the presence of mind, and I don't know why, and I wish I didn't have to do this, but I actually looked up and said to the person, active shooter, and they said yes. So they didn't know where the shooter was at that time. They didn't know if it was happening at multiple hotels. And so they went into some sort of security plan, and they got us out of that dining room as quickly as possible. And of course, by the time I woke up, I realized that 60 people had died because a mass shooter using a bump stock attachment to a semi-automatic weapon had done target practice and killed these people. And I traveled home with people who had been shot, been grazed or had shrapnel. I got out of there as soon as that hearing was over on Monday because I was so shaken up by it. And the fact that there is not a consensus, Republican and Democrat and others, about banning bump stocks, and that you can't use existing laws the way the subject matter expert ATF did to say this conversion kit of creating and putting this piece and replacing the back handle up against your shoulder of a rifle or some sort of semi-automatic weapon, which creates an ability to shoot 600 to 700 to 800 bullets per minute. Because Clarence Thomas, relying on pro-gun propaganda as part of his opinion writing, thinks that, oh, well, you're pulling the trigger 800 times in a minute. You are not pulling the trigger 800 times for a minute. And that's how he distinguished machine guns from what happened here. And that's where the walk like a duck and talk like a duck came from with Judge Sotomayor. You're not doing that. Your shoulder and the recoil is creating a mechanism that is allowing the weapon to fire that many times. And if you have a semi-automatic weapon, which is still legal, you just made it into an automatic weapon. And that's exactly what the shooter did at Mandalay Bay that night. So what you have is they've created for themselves, because we need to take on all agency work. And if we don't see it in the literal text, we're not going to allow for reasonable interpretations by the agency. This is the result. The result is between now and the time that the Democrats take back Congress and they can actually pass a bump stock law, banning law. Unfortunately, you and I are going to have to count the mass shootings using bump stocks between now and then.
And apply this logic or illogic by the right-wing Supreme Court right now. Every single agency action, unless Congress specifically used magic words and had the foresight to predict inventions in the future that didn't exist at the time it legislated, everything an agency, all the action Congress envisioned the agency to do, the agency will not be permitted to do. Bump stocks weren't created until the early 2000s. So in 1986, Congress was pretty smart. They recognized the issues that were happening, but that were on the horizon. They couldn't predict the name of all of these devices, so they described the devices that they wanted to ban. And Congress, when it functioned in a bipartisan way, did that. And they predicted the types of devices. They couldn't call it by the name because it didn't exist yet. So then when that thing came into existence, then the Supreme Court saying, well, it's not specifically mentioned by Congress as bump stock, so we're striking it down. Justice Thomas said the following: Congress has long restricted access to machine guns, a category of firearms defined by the ability to shoot automatically more than one shot by a single function of the trigger. Semi-automatic firearms, which require shooters to re-engage the trigger for every shot, are not machine guns. This case asks whether a bump stock, an accessory for a semi-automatic rifle that allows the shooter to rapidly re-engage the trigger and therefore achieve a high rate of fire, converts the rifle into a machine gun. We hold that it does not, and therefore we affirm. So that's how Thomas puts it. But take a look at what Justice Alito says, and this is what I mean with the gaslighting. Justice Alito goes, in a concurring opinion, I join the opinion of the court because there is simply no other way to read the statutory language. There can be little doubt that Congress enacted 26 U.S.C. section 5845B, that's the machine gun ban. It says there can be little doubt that the Congress that enacted that statute would not have seen any material difference between a machine gun and a semi-automatic rifle equipped with a bump stock. But the statutory text is clear and we must follow it. He's even saying in this opinion, when Congress enacted it, they would not have seen a material difference between the exact thing, the machine gun they were banning, and a semi-automatic rifle equipped with a bump stock, because if it looks like a duck and quacks like a duck, it's a duck. That's exactly what Justice Sotomayor is saying in the dissent. And then Justice Alito says there's a simple remedy, though, for all of this. Congress needs to amend the law. That's not a simple remedy because the MAGA Republicans in Congress are cheering this decision because they're bought and paid for by the NRA. I wish it was a simple solution. I wish our government functioned and worked, but we have MAGA Republican congressmen dressing up in long red ties, showing up to a convicted felon's criminal trial and attacking a judge's daughter. We'll be right back. And when we come back, I want to chat a little bit about that decision on women's reproductive rights. Then let's talk about Judge Eileen Cannon. I want to remind everybody that on patreon.com/legalaf, I'm going to be doing a lecture this weekend on all of these Supreme Court cases this term. It's going to be thorough. It's going to be detailed. It's going to be geeky. And if that's your stuff, go to patreon.com/legalaf. Legal AF. I think you will enjoy it. Also, we don't have outside investors, so it does help the growth of this show and this pro-democracy network. We'll be right back after our last break of the show.
Life insurance gives me peace of mind, especially when so much of what happens in life is unpredictable. But a good life insurance plan gives your family a financial safety net to protect against some of the unknowns. Policy Genius is the country's leading online insurance marketplace. It makes choosing the right policy for your family easy and quick. With Policy Genius, you can find life insurance policies that start at just $292 per year for $1 million of coverage. Some options are 100% online and let you avoid unnecessary medical exams. As you know by now, I'm a dad-to-be in about a month, and I can't even begin to explain how much better I feel knowing that if something were to happen to me, the ones I love most would be taken care of. Policy Genius helps you easily compare your options from America's top insurers in just a few clicks. Their award-winning agents can even walk you through the process step by step. Your work life insurance policy may not offer enough protection for your family's needs. Even worse, it may not come with you if you leave your job. Policy Genius has no incentive to recommend one insurer over another, so you can trust their guidance. They have thousands of 5-star reviews on Google and Trustpilot from customers who found the best fit for their needs. Get peace of mind by finding the right life insurance with Policy Genius. Head to policygenius.com/legalaf or click the link in the description to get your free life insurance quotes and see how much you could save. That's policygenius.com/legalaf. Have you heard that the flavored air category is quickly becoming the leading alternative to vaping and smoking? It's a whole new movement towards better habits, led by the sponsor of today's video, Fume. Fume is an award-winning flavored air device, and flavored air isn't like vaping. If vapor was compared to sticky soda, Fume cores are closer to herbal teas. Fume has lots of delicious flavors to choose from, like crisp mint and orange vanilla. With flavored air, you can satisfy your oral fixation through a passive diffusion system that utilizes no electronics, vapor, or combustion. Instead, Fume draws flavor to your mouth. Fume fills the void ditching a bad habit can leave. There's no vapor, and you can use it anywhere. There's no nicotine, and it's not addictive. The non-toxic flavors are a guilt-free alternative. Fume doesn't use any batteries, so you'll never need to charge it. The design is super sleek, it looks awesome, and you can truly feel the weighted, high-quality design. I mean, one of the fun things about Fume is that it's made to fidget with and calms anxiety with magnets, snaps, and clicks. Fume continuously invests in third-party studies to ensure the safety of their products. My favorite Fume flavor is the orange vanilla. It's just as delicious as it sounds. And look, if you're trying to kick your bad habit, I couldn't recommend Fume enough. Fume has served over 300,000 customers, and you can be the next success story. For a limited time, use my code LEGALAF to get a free gift with your Journey Pack. Head to tryfume.com. That's tryfum.com and use code LEGALAF or scan the QR code on the screen to get a free gift with your order today.
Michael Popak, you truly do have glasses for each ad read, and it is obvious to me that you specifically tailor the glasses to the ad read. Like you very specifically pick out that glasses or that. I was joking about it with the other one, but you clearly do that, right?
Did you see that the shade of the lens I was wearing matched the Policy Genius promo?
Yeah, and one of the things I noticed too is that your glasses don't reflect the screen in front of you also. So you really thought this out. I think that it's really well executed, and I just want to let you know I appreciate it, and I'm sure the legal AFers do as well. Look, let's talk about this FDA v. Alliance for Hippocratic Medicine case. It was decided on standing grounds, but this is the case where, and you and I talked about it when originally this MAGA judge in the Northern District of Texas, Matthew Kaczmarek, who's made a lot of rulings like this before, and prior to becoming a federal judge, he worked for a lot of groups that basically wanted to ban all types of women's reproductive rights and in the most extreme way possible. This is someone who's now a federal judge. And so when he got this case, he made a ruling that mifepristone is banned. It can't ever be distributed or sold. And then it went up to that ruling was stayed. It went to the Fifth Circuit. There was some circuit conflicts as well. Another case was decided in Washington. Anyway, the impact of the rulings banning mifepristone were stayed, worked its way up to the Supreme Court finally. But here, the United States Supreme Court, notably, if our viewers are saying this case involves the FDA and FDA regulations, but Ben and Michael Popak, you just said that the Supreme Court is gutting any type of regulatory actions by agencies. So how is the FDA's regulation in this case allowed to persist? It was a 9-0 ruling. It's a unanimous court ruled that mifepristone can be sold, that the FDA, they didn't necessarily say that the FDA could do it, but they basically could have regulations to allow mifepristone. But what the ruling was is that the right-wing groups that identified themselves as pro-life groups, which that terminology I never want to buy into. That's why I say they call themselves that were filing the lawsuits against the FDA did not have standing to enter the court. So on a technicality ground, the Supreme Court threw it out, but they didn't reach the issue or the merits of the case. So mifepristone can be sold and distributed as it always has. But I'll toss it to you. The Supreme Court seeming, though, to give a somewhat roadmap for future litigants to try to find a way to ban it.
Yeah. It's not as great as mainstream media has reported it. 9-0 mifepristone it hasn't been anything. The standing argument, which courts use when they don't want to reach the merits yet, Kavanaugh writing for the majority. The way I reconcile what you and I said earlier about the rollback of agency discretion and deference to agency action with this case is they never reached the issue of the agency action, but they have invited a future case next term, or while they continue to have the 6-3 majority, in order to finally rule on the use of medicated abortion in the country, having already taken away a constitutional right for a woman to choose. More than 12 states, I think 13 states, have banned abortion outright, meaning you can't use medicated abortion pills, mifepristone, and its companion drug in those states. That was not touched by the United States Supreme Court. How you reconcile in now a patchwork quilt country where it is literally the North versus the South, basically, when it comes to women's rights and women having equal rights. Kavanaugh, created this standing argument, which he summarized as, what's it to you? Literally. I thought it was like a New Yorker writing the opinion, meaning in order for you to have standing, you have to show that the governmental action and your injury, there's a logical chain that connects those two things. And if you have no injury, or you have governmental action but no injury, or injury but no governmental action, you're not going to be able to come into court and argue about it. And since none of these quote-unquote doctors representing this AstroTurf company that was literally created and incorporated in order to bring this case, they were literally incorporated in the very town that this Northern District of Texas judge sits in. They didn't exist before the lawsuit, and I'm sure, even though you can find them on their website, they don't really exist. It's this alliance of Hippocratic medicine, which I call the alliance of hypocritical medicine, which is a bunch of doctors who did not prescribe mifepristone, who did not perform abortions on women who had some sort of mishap using mifepristone, but wanted to stop others through a national ban of prescribing mifepristone. And the Kavanaugh was like, what's it to you? You didn't do it. Their argument was, well, if somebody uses it and things go awry, I may be called upon to provide an abortion that I don't want to have to provide. Then we're in the whole world of EMTALA, the emergency medical treatment, federal law about what has to happen in hospitals that accept federal aid in terms of the life of a mother, which is going to come out in another ruling, I presume, next Thursday. We'll talk about the timing of these rulings, including the couple that we're waiting on, and so all of this is just an invitation for the future proper standing plaintiff to challenge the FDA having approved in 2000 this drug. Let me tell you straight. Most women obtain abortions through medicated abortions through mail or telehealth, and these are the products that you use. It has been determined by the FDA through years of study that it is safer than, not as safe, safer than aspirin or Tylenol for women to use for this purpose. But when the right set of plaintiffs come together, which would be, I used mifepristone and something went bad for me, or I was the doctor for a patient who used it and something went awry. They're going to trust me. They're looking for that. They're looking for that plaintiff right now, and they will refile the case in front of Judge Kaczmarek again, because Texas will not recognize, despite there being recommendations by the federal judiciary conferences that there should not be forum shopping. Texas has said they're not going to recognize it. So you want to go file your case in front of the judge who used to be the general counsel for a right to life movement. I'm not making this up, and has been public about his being against abortion. Then you see in the opinion, another opinion written by Clarence Thomas. It's another, I don't want to be rude, but it's another older male, childless male talking about women's reproductive rights and talking about, and listen to the language he used, Ben. I'm sure you saw it, you caught it. He talks about, he paints the world into two places, divides it into two worlds. Abortionists, that's a phrase that had been used by people filing amicus briefs and in different types of ridiculous literature, but never apparently in a Supreme Court decision by a Supreme Court justice. So he calls the people that are in favor of a woman's right to choose abortionists, and with all of that negative connotation and morality that's embedded in that. I almost said impregnated in that, embedded in that. And he calls the people that the women that go to a doctor, it's always performed by a doctor, to have an abortion, a client, not a patient. And he contrasts that with doctors who have patients. It's just in the language that they have chosen, you see the moral legislation that's going on, the church-based stuff that's going on at the court system. And so I took cold comfort with the 9-0. Like, for now, you can use mifepristone in the states where you can actually have some sort of abortion, which are becoming more and more limited. But there will be, and you and I will talk about the next case that will come where standing is not an issue. And then you're going to see them talk about, is there a right to use this? And was the FDA right or wrong in its research and in the delegation from Congress down to the FDA? And then we're right back to the administrative issues that you and I talked about. One last thing on the Supreme Court before you move us to canon. Look how long they are taking to issue the ruling that we've been waiting for, with the hope that if it comes out in one direction or another, we can restart the DC election interference case against Donald Trump with Judge Chutkan. They waited till the last day of oral argument in April to hear the case. They could have done it any other time, a month earlier at least. And instead of, we've had 3 days or 4 days of oral of decisions being issued. Okay. And we were waiting patiently. They said, we're going to do 2. We're going to do 2 this past week. We're going to do Thursday and Friday. We're like, okay, Thursday, Friday. Here we go. The first one comes out, it's 9-0 mifepristone. And then the bump stock comes out. Then a few other ones come out. Okay, let's go. Where's immunity? No. So now we got to wait till next Thursday, right? To get maybe the immunity and whether there's going to be a ruling on obstruction of Congress, which is 2 of the 4 counts for Donald Trump and was used against 300 Jan 6 defendants already, including those that have been convicted and sentenced under it, to determine whether that was proper or not. We're going to wait till the very last gasp of this term, meaning every day that goes by is one less day that Judge Chutkan has to get that trial up and running, even if she can, before the November election.
Yeah, no, the Supreme Court did everything in their power to make sure that the Washington, D.C. case, by all accounts, could have went despite Donald Trump's ridiculous absolute presidential immunity appeal, who this right-wing Supreme Court may not find ridiculous and may say that their definition of conservative is conserving the monarchy and reinstituting the idea of kings with absolute immunity. We'll see what they actually rule. But what's been clear is that they've done everything in their power to prevent intentionally the right-wing Supreme Court to stop that trial from happening, and they will release that ruling at the very last minute. And I think when they release it, it will, no matter what the outcome is, I think it will have strings attached to it that will, even if there is no absolute immunity, which is a ridiculous, the most ridiculous concept ever in the world to me, they will have Judge Chutkan in DC have to do some work that will also ensure that there's no way that trial can ever take place before the election, and that's what they want. But look, I mean, we know these justices. I mean, you have Clarence Thomas, who's getting bribed. Like, we know the right-wing justice Clarence Thomas has been bribed over $4 million by billionaires to get him to make rulings. And for MAGA Republicans, that's okay. And for Justice John Roberts, that's fine. We know that you have Justice Alito, who violates the flag code, but which in and of itself is an issue, which is a violation of the law, but flies upside down flags, the sign of imminent distress, to show solidarity with insurrectionists, then blames his wife for it, then flies the other insurrectionist flag at his New Jersey beach house. Then we have the audio recordings of the kind of just dystopian ways of Justice Alito even talking about these things. Then we have the audio recording of his wife, who I don't know one way or another if she was a few drinks in or if that's just the way she is in general. I don't want to assume one way or the other, but the way she communicates with people at the event is by meowing to them. And she goes, "Hey, meow, 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 meow." And I'm listening to this, Popak, and I'm like, you're communicating via meows?
The person's name was Kat, but I still doesn't give you the reason to go meow, meow when you see the person.
Yeah, I mean, your last name is Popak. I don't treat you like the Pope. I don't go, I mean, I understand that people have names. That doesn't mean that you go meow, 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 meow. Hey, Michael Popak. What are we talking about? Anyway, going to Judge Eileen Cannon, though, who fits the mold of a MAGA judge. Let me just set the stage super quickly of what she did.
By the way, when you say Cannon, you don't go boom.
Exactly. I don't go, "Hey, Judge Cannon, boom, 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 boom." I mean, adults usually don't communicate via noises, especially at the Supreme Court level at those types of meetings. But I don't know. Maybe look, they do have shaman, QAnon shaman, and I should mention Clarence Thomas's wife being at the insurrection and then sending messages to Mark Meadows, the chief of staff at the time, in these apocalyptic terms, like, we need the armies from heaven to descend and dethrone and destroy, I'm like, oh, there's some strange stuff. Anyway, Judge Eileen Cannon, not boom, 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 not that. Judge Eileen Cannon, not Cannonball. So she issued a few orders this week. One of them was on the deadline for Donald Trump to disclose the expert witness in the Mar-a-Lago document case, where the original deadline was November of 2023, and that date was then adjourned twice, and then the new date was June 10th. You disclose your expert in the case, expert deadline. on the day the expert disclosure was due. This is how the arrogance of Trump and Trump's lawyers and how they know Cannon's in the bag for her, right? A bag for them, is that on the day the disclosure is due, rather than disclosing the expert, they ask for an extension the day it's due. And then they say the reason why they need the extension in the filing, which is right there, you can read the filing for yourself, is they say that the expert they were going to hire told them over the weekend that the expert can no longer be their expert. So then, so they waited until the weekend. Then the expert said, I can't be the expert. Then on Monday, on the disclosure deadline, when you're supposed to give a pretty detailed disclosure, you go, hey, Judge Cannon, we need some more time. Any other federal judge would sanction you for that type of conduct. By the way, Judge Cannon had previously admonished Special Counsel Jack Smith for not meeting and conferring for a length of time that Judge Cannon, in whatever arbitrary view she has, was sufficient for her when Donald Trump was lying and saying that the FBI was trying to assassinate him and the DOJ wanted to kill him. Trump's just like lying about that, taking the standard use of force policy that exists in every search warrant and claiming that, oh, they're coming after me, they want to kill me. And Jack Smith met and conferred with Trump's lawyers. Trump's lawyers were like, because Jack Smith wanted to modify the conditions of Trump's release and basically have a gag order saying, stop lying about that. You're going to get DOJ and law enforcement killed. And Trump's lawyers were like, yeah, we don't want to meet and confer with you. Let's schedule it sometime next week. So Jack Smith filed with the court sufficiently after giving Trump's lawyers sufficient time to meet and confer. And when Jack Smith did it with sufficient time, Judge Cannon admonished him. And Judge Cannon goes, the court finds that special counsel's pro forma conferral to be wholly lacking in substance and professional courtesy, and she rejected his request for not being courteous enough after Donald Trump was about to get law enforcement killed, while Jack Smith gave plenty of time. But Donald Trump, the day of the deadline, says, you know what, I need some more time. Give us an extension. And then she goes out of her way and says, granting it for good cause. This was her order. The court finds that good cause exists for the extension request and that no prejudice to the special counsel or the proceeding will result from granting the relief sought. And then she says, moving forward, any requests or extensions or enlargement must be filed sufficiently in advance of the deadline at issue. So, hey, maybe in the future, Donald, you can just do it a little more in advance than like the day the disclosures was due. But I got your back. That's the message that was sent there. The other thing that Judge Eileen Cannon did was, while she denied a motion to dismiss filed by Donald Trump that, frankly, I couldn't even comprehend what he was even saying the grounds for dismissal of the indictment were for, duplicative allegations and saying that it was too long. It literally made no sense, Donald Trump's motion. While she denied Donald Trump's motion to dismiss, she struck certain allegations in there that she said were too prejudicial to Donald Trump. And here's the allegations that she struck. In August or September 2021, when Donald Trump was no longer president, Trump met in his office at the Bedminster Club with a representative of his political action committee. During the meeting, Trump commented that an ongoing military operation in Country B was not going well. Trump showed the PAC representative a classified map of Country B and told the PAC representative that he should not be showing the map to the PAC representative and not to get too close. The PAC representative did not have a security clearance or any need to know classified information about the military operation. As George Conway says, it seems that in Judge Cannon's view, prejudicial means conclusively demonstrative of the defendant's criminal state of mind. He's absolutely right. That paragraph is clearly an important paragraph to go in the indictment. It shows Donald Trump's intent. If he's saying to someone, you shouldn't see these documents, it directly rebuts Donald Trump's other claim that he believes he was entitled to have them. It may be prejudicial to Donald Trump, but that's like saying all criminal complaints are prejudicial to the criminal because they talk about the criminal's crimes. So, Popok, that's what Judge Cannon did today. I think Jack Smith was certainly looking into whether there could be an appeal of that. It's still not necessarily one of those finite topics where you can seek interlocutory review, because it doesn't address a SEPA issue where you can have interlocutory review. There are a few other kind of finite areas where you can take the appeal midway through. But I know on your hot take, you thought that there's a potential, at least, that Jack Smith could could appeal this. But anyway, that's what she did. But I want to show the comparison, because what I want to show is that if Judge Cannon was a stickler for her calendar, the way she's being with the DOJ, and she's hard on them all the time, and hey, it's a pro forma meet and confer. I want 7 days, not 3 days. And that's who the judge is. Same way like an umpire in a baseball game, right? They establish a strike zone. And then if it's within the strike zone, you have a sense of, okay, this is at least the strike zone of where it is. But for Cannon, she truly just has one set of rules for the prosecutor and one set of rules for Donald Trump. And the set of rules for Donald Trump is whatever benefits you. And the set of rules for the prosecutor is whatever hurts you. One final point before throwing it to you. Judge Cannon's reputation, though, outside of this case, is to always be unfair to the criminal defendants' lawyers and to always be favorable to the prosecutors, almost no matter what the circumstance. That was the only rep that I got on her from people who have appeared, criminal defense lawyers who I know have appeared before. So she's adjusted the whole framing here as how can I help Donald Trump? And that's why I don't just want to like whine, oh, Judge Cannon's a bad judge, blah, blah. I just want to show you, here's how she made an order here. Here's how she made an order there. It's the exact opposite order with a very similar set of facts. In fact, far more egregious facts when it comes to the fact that there's life or death of FBI agents caused by Donald Trump's behavior. Pope, I'll give you the final word. I think I covered a lot of it.
Well, I'm not going to cover that, but I'm going to cover something else that worries me about Cannon. I agree with you. Under 404B of the criminal rule, she should have allowed to stay in the indictment the allegation that you read out loud. Susie Wiles is the person that is mentioned there. At the time, it was listed as a PAC representative, but we know now it's Susie Wiles, who's sort of this dark figure that's always surrounding Donald Trump, does all of his political action. She was involved with other communication between the co-conspirators. She's going to be a witness in that prosecution, by the way, whether the paragraph that references her is taken out or not. The judge seemed very concerned about, well, when the indictment may go back in writing to the future jury, and that, since it's an uncharged crime, I can't understand why it's included. To which Jay Bratt and others have said it's because it goes to intent and motive. This is the guy who said he magically declassified everything on the way out of the White House. Well, if he believed that, then why was he worried about showing Susie Wiles a document that he shouldn't show her? Don't get too close because it's classified. See, that's inconsistent, and that goes to willfulness and intent. I'm less concerned about that, although that's a terrible decision. Maybe they can ask, even if they don't have an appeal as of right, they can ask the 11th Circuit to go up on that one. But the one, I think they're just waiting, Ben, and they're keeping their powder dry. Because the one that I'm worried about, and I did a hot take on, is the one about Evan Corcoran. It's going to be her overturning a decision well made by Judge Beryl Howell, the chief judge at the time of the D.C. Circuit Court, about Evan Corcoran, the lawyer for Donald Trump, having participated in a crime or fraud with Donald Trump, which stripped Donald Trump of his attorney-client privilege and forced Evan Corcoran, who was the main lawyer for all things Mar-a-Lago and the documents and the interactions with the government and his own client during the relevant time period. He took 50 pages of single-spaced notes. I got to tell you, I've been doing this a long time. I've never taken, for a client that I trusted, 50 pages of single-spaced notes, including my mental musings and really damning evidence against Donald Trump, such as Donald Trump directing Evan Corcoran to make classified documents poof, and this is a bare paraphrase, poof, disappear from his collection before he turned it over to the federal government. So, and audio tapes, audio memo recordings that also this guy made, which you would never do normally, in which he's also has damning observations about his client, Donald Trump. That has been turned over to the prosecutors. We reported on it a long time ago when there was, it's all secret hearings, but we were able to glean what happened as Evan Corcoran was testifying to the grand jury, now stripped of attorney-client privilege, and had to turn over all those documents. They have moved to suppress all of Evan Corcoran's notes and damning testimony and keep him off the stand in this case. And it is pending before Judge Cannon. It will be determined at one of these crazy hearings of hers in the next 2 or 3 weeks. If she has the temerity, with her lack of experience, with 10 trial days under her belt, to overturn Beryl Howell, who's a 20-year judge, a litigator before that, who's well-respected, shortlisted for the United States Supreme Court, overturns her judgment and finds as the trial judge that should be suppressed, then we're off and running to the 11th Circuit because she's dead wrong and she didn't, and she's overstepped her boundaries. That's the one I'm worried about. And that's the one that's coming up in this next round of hearings that are stacking up. And I'll leave it on this. Now the only active case left of the 4 at the moment is Mar-a-Lago. He already got convicted of the 34 felony counts. New York is over. All is over except for the shouting at sentencing, right? Georgia is currently stayed, subject to a motion to dismiss that Fani Willis has filed in order to get the appeal of Donald Trump dismissed and get that case out of the mud. DC election interference, as we said earlier in the podcast today, is awaiting the decision. Apparently, on the last day before they go on the Republican side, they go on their junkets paid for by MAGA federalists and people lobbying them for decisions on the bench. The day they leave for that, that's the day next Thursday, probably, we're going to get that decision when it's too late to do anything. The only case left, which means now Donald Trump's lawyers, fresh off their loss at the New York court, can just train their resources and attention on the friendly judge that they think at Mar-a-Lago. And they just keep hitting that button because good things happen for them in her courtroom. It's the only judge that they reliably and consistently can get a positive ruling because she has such a jaundiced view of the Department of Justice and is so negative about them, and much to the frustration and flummoxing of the prosecutors. And I think they're just waiting for her to make whatever crazy ruling it's going to be about Evan Corcoran's notes and suppression, and ultimately the hearing, which will probably be part and parcel or over a 2-day period, the way she likes to do it in her courtroom, dragging everybody into Fort Pierce, is she's also going to rule about the suppression of the search warrant, which is if the prosecution by her ruling were to lose the evidence that was under the search warrant because they didn't allegedly keep the sanctity of each box in the exact order that it was in, even though it was scanned and reviewed and inventoried and a magistrate already took a look at it for a short amount of time. If she does any part of that, we're off to the 11th Circuit and maybe with her replacement.
It's a case where Donald Trump stole nuclear secrets. I don't want to ever forget that. He stole our nuclear secrets. He stole war plans. He stole real serious documents and data, and his claim in one of his motions is that it now belongs to him and it no longer belongs to the government of the United States, because he claims that he telepathically declassified it. No one knew about it, but he telepathically did it. And he claims under the Presidential Records Act, it's now his personal stuff. So he claims that our nuclear codes are his personal property, me, that American war plans are his personal property, me. And that's the case that Judge Eileen Cannon is presiding over and doing all of these things. And so this show goes kind of full circle, if you will, where, I say there's a lot I could predict. A lot I can think through different scenarios, But I just think the saddest and most shocking part about this is on just some objective reality stuff. Nuclear records don't belong to. What are you talking about? How could that even be an argument? You're absolutely immune like a king? What are you talking? Well, this is the United States of America. What are you talking about? We can do our deep dive statutory analysis like you and I do all the time, Popak, but I don't want that to shadow or cover some of these basic things. This is the United States of America. We don't have kings. You don't get to steal our nuclear records. War plans and nuclear codes do not become your personal property, where you have your valet hiding the documents, caught on surveillance footage. It looks like a Ace Ventura parody of the guy hiding these things. What are we talking about? That's the part about it to me that what I hope this show can do is bring us together in terms of whether you're a Democrat, an independent, a mainstream Republican, if you're a real conservative, independent, liberal, progressive, that we can at least agree on logic and fundamental things that we shouldn't disagree on and we never disagreed on with before. And that's what's at stake. And that is what's always underpinning, I think, the law and the detail and the deep analysis that we do. There's some of this common sense stuff that I don't want to ever lose sight of. I want to remind everybody about our Patreon, patreon.com/legalaf. Going to be posting a new lecture tomorrow. And then Michael Popak, I know you have some big family developments coming up soon, but I hope before you get too busy, although you're probably very busy now, maybe you and I together, but at least I'll pledge to do this. In the next week, I will set at least a Zoom meeting with everybody who joins the Patreon, and you could ask me any legal question at all that we can do on a Zoom. And I don't want to be, I know right now, Popak, you're kind of in the home stretch of some major family news. So I'd love for you to join me.
Let me make two comments about that. One, I'm really excited about your Patreon, and I'm a big lover of the Supreme Court analysis stuff, which for a long time kept us afloat on Legal AF. When you and I founded it 4 years ago, there were times when we were like, well, thank God the Supreme Court's in session, or they're about to issue their orders, because, we were looking for really great content to bring, and we're always curating, thinking about it. So we've been on top of the Supreme Court stuff even before the Trump prosecution stuff. That's always been our jam, as we like to say around here. So I'm going to tune in. I watch what's on our Patreon. I'm going to tune into your tutorial about, which is for non-lawyers, just to be clear, we're nerding out, we're geeking out, but it's for non-lawyers and lawyers alike. And we gear it the way we do here without being patronizing, no pun intended. We try to do it in an informative and entertaining way. So the takeaway from it is that it is a valuable commitment of your time, 5 minute, 10 minute, 20 minute, whatever it's going to be. And that you walk away with new knowledge in an informative and entertaining way that you didn't have before. That is our commitment to you. As to the Zoom thing, totally in. This would be the good last week to try to do that. And then you and I will also do a duet that we're going to do as well, that we're going to do quarterly, that we're due for, that we'll do on a topic that we haven't done together and we haven't done here on Legal AF as exclusive content.
Love it, love it, love it. Thank you all, the Legal AFers. We appreciate you. So join that Patreon. We'll put a secret link in for sometime this week. We'll probably do it. We'll figure out a good time to do it. Yeah. This week, probably middle of the week or Tuesday. We'll figure out a good day. You and I, when you're doing Legal AF on Wednesday, so we'll figure that out. And one more time, patreon.com/legalaf. Patreon.com/legalaf. Thank you everybody for watching. We appreciate you, and we'll see you next time. Have a wonderful day.